Serana versus Sandiganbayan, GR number 162059, January 22, 2008. This is for criminal procedure, specifically jurisdiction over the subject matter of the offense. Jurisdiction over the subject matter is the power to hear and determine the general class to which the proceedings in question belong. Jurisdiction over the subject matter is conferred by law and not by the consent of any or all of the parties or by erroneous belief of the court that it exists. It is not procedural, but a matter of substantive law which is conferred by law. If the court has no jurisdiction to hear and decide a criminal case, it cannot take cognizance of the case. Facts. This case was about the jurisdiction of Sandiganbayan to try a government scholar along with her brother of swindling government funds. Petitioner Hannah Eunice D. Serana, a senior student of the University of the Philippines Cebu, was appointed by then President Joseph Estrada as the student regent of UP. During her term, Serrana allegedly discussed with then President Estrada a proposed renovation project of a hall annex in UP Diliman. Allegedly, Serrana promised to President Estrada that after renovation, said hall will be named after the latter. Hence, then President Estrada gave 15 million pesos as financial assistance for the proposed renovation. However, the said project did not materialize and Serrana failed to return the 15 million pesos despite demands. It was also alleged that the said amount was encashed by Serrana's brother, Jade Ian D. Serrana. Due to this, the succeeding student regent and the system-wide alliance of student councils within UP filed a complaint for malversation of public funds and property with the Office of the Ombudsman against Serrana and her brother, as they alleged in the information that the source of the 15 million pesos was the Office of the President. The Ombudsman, after due investigation, found probable cause to indict petitioner and her brother, and the same was filed before the Sandiganbayan. Petitioner Serrana filed a motion to quash and argued, among others, that Sandiganbayan has no jurisdiction over the offense charged, which was estafa, as it was not among those crimes cognizable by the Sandiganbayan as determined by Section 4 of Republic Act number 3019, which is otherwise known as the Anti-Graft and Corrupt Practices Act as amended. Petitioner Serrana argued that Sandiganbayan only has jurisdiction over crimes covered by Title 7, Chapter 2, Section 2, Crimes Committed by Public Officers, Book 2 of the Revised Penal Code. And since estafa falls under Title 10, Chapter 6, Crimes Against Property, Book 2 of the Revised Penal Code, said offense is not within the Sandiganbayan's jurisdiction. The Ombudsman opposed the said motion and countered, among others, that Section 4, Paragraph B of Presidential Decree number 1606 clearly contains the catch-all phrase in relation to office. Thus, the Sandiganbayan has jurisdiction over the charges against Serrana. Sandiganbayan denied Serana's motion to quash the information and her motion for reconsideration for lack of merit and held that the Ombudsman correctly ruled on the matter. Thus, Serana filed a petition for certiorari before the Supreme Court, which assailed the resolutions of Sandiganbayan. Issue: whether Sandiganbayan has jurisdiction over the offense charged in the information, which was estafa. Ruling: the Supreme Court said yes, Sandiganbayan has jurisdiction over the offense charged in the information, which was estafa. Section 4, Paragraph B of Presidential Decree Number 1606, as amended by Republic Act Number 8249, provides that Sandiganbayan has jurisdiction over other offenses of felonies, whether simple or complex, with other crimes committed by the public officials and employees mentioned in subsection A of this section in relation to their office. Evidently, the Sandiganbayan has jurisdiction over other felonies committed by public officials in relation to their office. The Supreme Court saw no plausible or sensible reason to exclude estafa as one of the offenses included in Section 4, Paragraph B of Presidential Decree Number 1606. Plainly, estafa is one of those other felonies. The jurisdiction is simply subject to the twin requirements that first, the offense is committed by public officials and employees mentioned in Section 4, Paragraph A, Presidential Decree Number 1606 as amended, and that second, the offense is committed in relation to their office. In this case, the information alleged in no uncertain terms that Serana, being then a student regent of UP, while in the performance of her official functions, committing the offense in relation to her office and taking advantage of her position with intent to gain, conspiring with her brother, Jade Ian D. Serana, a private individual, did then and there willfully, unlawfully, and feloniously defraud the government. Clearly, there was no grave abuse of discretion on the part of the Sandiganbayan when it did not quash the information based on this ground. Therefore, Sandiganbayan has jurisdiction over the offense charged in the information, which was estafa. In applying the foregoing, the petition was denied for lack of merit.